So there's been one specific case that has gone to the Ontario Court of Appeal, which is the highest court in Ontario. The next step would be the Supreme Court of Canada. This was one of my cases, which I had looked at when I was in a cat-DAC situation. And so it was interesting about this claimant, Mr. Liu, was that he had 3 GCS scores all within 40 minutes. So he had a 3, an 8, and a 12. So my view was that he met quite readily. There were very clearly 2 GCS scores, 9 or less, and that the time frame was reasonable. Basically, they were taken by first responders within 45 minutes of the accident occurrence. So, seemed very straightforward. Didn't think this one would ever be challenged. But sure enough, there was a mounting defense force by, I think this was an Aviva case, and Dr. Arthur Amies and a couple of other very defense-oriented physiatrists at that point in time. Dr. Amies does both sides these days. Provided an opinion that was very much grounded in neurosurgical clinical practice. Namely, that from a neurosurgical standpoint, it's been a fairly standard principle in care that when looking at lowered GCS over a period of 6 hours, if someone continues to have a significantly depressed GCS score at the 6-hour point, in other words, this becomes a trigger for neurosurgical intervention, typically evacuation of a hematoma, for example. So what Dr. Amies and some others suggested was that that reflects standard of care. Therefore, if we're going to be considering whether an individual meets catastrophic impairment on the basis of GCS, one should be really looking at the GCS score at 6 hours post-accident. So they were successful in convincing the initial trial judge that that was the appropriate added consideration, qualification of this criterion. And so it was determined that from that point onwards, there were many, many cases decide on that basis that the GCS of less than 9 before the 6-hour point would not be considered a catastrophic impairment. Only those after 6 hours would be. So that was carried up until basically the Ontario Court of Appeal occurred in 2009. And the judge in that situation determined that provided there is a brain impairment, all that is required is 1 GCS score of 9 or less within a reasonable period of time following the accident. So basically basically remove any suggested need for a 6-hour window to first occur before or in addition to the qualification of 9 or less.